190 FH. This time and date set for pretrial. Ms. Booms is present, represented by attorney Nicole B. Becker. People are represented by prosecuting attorney Timothy J. Rakowski. Court is in receipt of an amended information that's been filed in this case. Mr. Rakowski, you filed this on behalf of the people?
Yes, Your Honor.
Okay. And what is the status of the file at this time?
Your Honor, we've had several conversations, Your Honor, with, in an effort to figure out where we can come to an agreement. At this point, Your Honor, there is a plea offer regarding the amended information, and we wish to take it.
Very well. Ms. Booms, would you please raise your right hand?
Do you solemnly swear?
Tonight, a former ALLEDGELY school employee was arraigned today accused of having sexual contact with a student. Kimay Booms was a student nurse and an assistant with the agricultural program at ALLEDGELY when she resigned in May. Her resignation came as school officials suspended her after they were made aware of an incident on a school bus involving a 16-year-old male. Today, the 33-year-old was charged with 1 count of criminal sexual conduct, 3rd degree. The age of sexual consent in Michigan is 16 unless the elder party is a school employee where the student was enrolled and the suspect used that position to establish a relationship with the student. In that case, the age is increased to 18.
Thank you. Mr. Rakowski, would you please state the terms of the plea agreement on the record?
Yes, Your Honor. Ms. Booms will be pleading to count 1, gross indecency between male and female. The date of offense for that one would be July 24th, 2024. Also pleading to count 2, criminal sexual conduct in the 4th degree. And the date of offense there would be the date range of between January 1 of 2024 through May 1st of 2024. People agree to dismiss the original charge that was filed in this matter.
All right. Ms. Becker, is that your understanding?
If I can have one.
Go ahead. All right. Is there anything we need to clear up on the record regarding the plea offer?
Yes, Your Honor. As it relates to count 2, which is the criminal sexual conduct 4th degree, that date that we would rely on is April 29th.
Becker, is that your understanding as well?
Yes.
Okay. So, Ms. Becker, is that your understanding then of the full plea agreement?
It is, Your Honor.
Ms. Booms, did you hear the terms of the plea agreement outlined just a moment ago? Is that a yes?
Yes.
And do you wish to accept them?
Yes.
Are there any other terms of this plea offer that we've not covered? Ms. Becker, do you-
No, Your Honor.
Mr. Rakowski?
I agree.
Ms. Booms, you're not on any term of probation or parole, are you?
No.
Have you had sufficient time to speak to Ms. Becker about this?
Yeah.
Do you have any questions of her before we go any further?
No.
And is there anything affecting your mind or brain making it difficult to make important decisions?
No.
Do you have a clear mind?
Yeah.
Very well. All right, you're charged in the amended information in count 1, gross indecency between male and female committing/procuring. That is a felony carrying a maximum prison sentence of up to 5 years and/or a fine of up to $2,500. And there's mandatory AIDS and STD testing. Also, the Sex Offender Registry Act would apply. You'd be a tier 2, which means you'd have 25 years of registry on the Sex Offender Registry Act. Do you understand that?
Yes.
Thank you. As to count 2, you're charged with criminal sexual conduct in the 4th degree involving a student. That is a circuit court misdemeanor or high court misdemeanor carrying a maximum prison sentence of up to 2 years and/or a fine of up to $500, mandatory AIDS STD testing, DNA to be taken upon arrest, and also the registry of tier 2, 25 years. So you understand the maximum sentence that could be imposed in that count as well.
Yes.
With all that in mind then, counsel, how does your client plead to both counts 1 and 2?
Thank you, Your Honor. Your Honor, she is going to plead guilty. I would ask at the appropriate time that be allowed to forward you regarding her guilty plea.
Very well. So guilty is to both counts 1 and 2?
That's correct.
Very well. Ms. Becker, have you gone over an advice of rights form with your client?
Your Honor, we've gone over all of this. It's been some time. So may I just speak to her for one moment?
Sure. There's a form right below you there as well.
Perfect. Thank you.
Time to review it.
Yes, Your Honor. I've refreshed Ms. Boone's memory. She recalls and she understands.
All right.
Would you like to sign?
If she would execute the document, if she feels that way, yes.
Thank you. Your Honor, we have executed this and I will supply that to the court. I'm just waiting.
And Deborah's right there. Ms. Booms, I'm not doubting your attorney, but you did sign this, correct? Now, before signing it, you did go over it?
Yes.
You understand the rights contained on the form?
Yes.
By pleading guilty, you're giving up those rights. Do you understand that?
Yes.
That means you will not have a trial of any kind nor have any opportunity whatsoever to contest your guilt. And all that remains after today will be for you to be sentenced. You understand that?
Yes.
If these pleas are accepted, you'll be giving up any claim that these pleas are the result of any promises or threats not disclosed to this court during this plea proceeding. You'll also be giving up any claim this plea is not of your own free choice. You understand that?
Yes.
Other than the terms of the plea agreement outlined by Mr. Rakowski, has anyone promised you anything such as leniency to get you guilty?
No.
You understand that no one can make any promises for me as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing sentence. You understand that?
Yes.
Has anyone promised I be easy?
No.
Has anyone threatened you to enter these pleas?
No.
Are these pleas of your own free choice? Sorry? Are these pleas of your own free choice? Are you choosing to enter these pleas on your own?
I decided.
Okay, so it's your own choice, correct? All right. Financial obligations are due and payable at the time of sentencing unless there's good cause shown. Do you understand that?
Yes.
And that you're subject to a 20% late penalty for any unpaid monetary obligation due 56 days following your conviction and sentence. Understand?
Yes.
Finally, if these pleas are accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeal from the conviction and sentence pursuant to these pleas will be by application for leave to appeal and not by right. You understand?
Yes.
Very well. Ms. Becker, please establish a factual basis relative to counts 1 and 2.
Thank you, Your Honor. With regards to count 1, that's the gross indecency. Kimay, were you in the city of Bad Axe in July 24, 2024?
Yes.
And was there a point in which the victim in this case had requested that you meet him up someplace that was a place in public?
Yes.
And at that time during that meeting, was there a time when you masturbated the victim on the outside of his clothing?
Yes.
And at the time you were not a parapro at Upley, is that correct?
Yes.
And that was County of Huron, correct?
Apologize, yes, County of Huron.
Okay, because
Yes,
I did hear
Yes.
City of Bad Axe.
I did, yep, I forgot the county. Thank you, Judge.
Any objection to the factual basis relative to count 1?
Could we have the basis for count 2 first? Because I'm going to tie them together.
Sure. Why does it
Yeah.
count 2?
Thank you, Your Honor. Your Honor, with regards to count 2, the criminal sexual conduct in the 4th degree, on April 29th, did you, of 2024, in the city of Upley, in the county of Huron, Huron County, did you in fact have an occasion to be in contact with the victim in this particular case?
Yes.
And at some point, did you in fact touch his buttocks?
Yes.
And that was for a sexual purpose?
Yes.
And he was 16 to 18 at the time?
Yes.
And he was at Upley School where you were in fact cared for the students as a parapro, is that correct?
Yes.
Thank you.
Mr. Rakowski, any objection to a factual basis?
2 questions.
Go ahead.
You were employed by the Ubley Community Schools, correct, Ms. Booms?
Yes.
And the victim in count 1 is the same person in count 2, correct?
Correct.
With that, I'm satisfied.
Any objection to the factual basis?
No, Your Honor, thank you.
Mr. Rakowski, you aware of any promises, threats, or inducements for this plea other than what's been disclosed?
No, Your Honor.
Ms. Becker?
No, Your Honor.
Has the court complied with the court rule concerning pleas? Mr. Rakowski?
Yes, Your Honor.
Becker?
Yes.
Ms. Booms, there's been no agreement made by this court concerning these pleas and what the sentence will be. Is that accurate?
Yes.
Ms. Becker, do you agree?
Yes, Your Honor.
Mr. Rakowski?
Yes, Your Honor.
Court will accept the pleas done freely. They're voluntary, understanding, and accurate. There's a sufficient factual basis, hence the court will accept the pleas and schedule sentencing for March 24th.
I'm sorry?
24th, March. If you're available.
Your Honor, how, for lack of better words, quickly are we able to get a pre-sentence report?
That's probably going to be the earliest.
That's gonna be there just because I've got another 2 or 3 line already.
Okay, so you said March
24.
24th. Just wanted to make sure. Okay, if that's the earliest, that's the date we'll take. Yes, thank you.
Sentencing March 24, 2025 at 9 a.m. Prior to sentencing, I'm ordering a pre-sentence investigation report, which be prepared, provided both counsel to court at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing, provided to counsel. Any objection to the scoring of the guidelines must be filed in writing with the clerk of the court no later than 7 days from sentencing. Ms. Booms must appear in the courtroom at time of sentencing. If there's any supporting documentation, must be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. Bond was set at $3,500, 10%. Mr. Rakowski, your position relative to bond.
No objection, continuing bond with the conditions.
I'm sorry, Ms. Becker, any comment relative to bond?
No, Your Honor, I would agree. Thank you.
Bond will continue as previously set.
Your Honor, may I just have one more thing?
Go ahead.
Thank you. With regards to the sentencing date and where we're at now in her bond. Although she has been, quite clear that she is only allowed to drop off and pick up her children at school. There are some basketball games that are not at the school, but they're away from the school. Would that be an issue for her to attend those?
Mr. Rakowski.
I guess we leave it to the court's discretion. Court knows from today, players.
What, is this her family or?
Yes, there's an 8-year-old and a 6-year-old.
At this time, I'm going to continue bond as previously set.
Okay. You're right. I should have also mentioned that it's not for high schoolers or older. It's literally the age of her children.
I still think under the circumstances, I'm going to continue.
Thank you, Your Honor.
Sorry. That'll be all. Off the record.